I started out doing work for Oscar Blues and Sierra Nevada and New Belgium when they were rolling into North Carolina. Those were the first first three breweries I worked for. So we got a lot of different touches on different issues for them as they came in. I worked with Wicked Weed here and saw that rise and spin off, and Highland and Highwire and Burial. All in all, we work with about 100 breweries here in North Carolina. In addition to that, we work with other manufacturers of alcohol products, spirits, wine, cider, sake, kombucha. If it's got alcohol in it and is regulated by the federal government or the state government, we're probably dealing with it or have dealt with it. I love working with startups in this space, and when I say this space, we look at craft beverages really in the macro in terms of where it is on the spectrum, and we believe that craft beverage manufacturing is part of a bigger craft lifestyle space, and that's how we approach our firm. That's how we've built it, and so we do lots of work in related industries in terms of the lifestyle components, so outdoor gear, biking, running, kayaking, smart growth, infill development, really being better stewards on the planet, leaving a shallower footprint and doing so in a way that is sophisticated and still business-like, but staying true to our core roots. I'll move forward on going forward on contract brewing, because that's what we're here to talk about. And at any time, if there are any questions or I need to go back and cover something, please raise a hand, put in the comments, and we'll try to address it. And I'll make sure that this PowerPoint is available for folks afterwards. If you ever need anything, certainly reach out by email or phone call, and I'll try to help get those questions answered. The basics of contract brewing and the way that I use contract brewing is a lot bigger than just what my state, which is North Carolina, calls contract brewing. My state calls contract brewing when a brewery, a licensed brewery, engages with another brewery to produce beer for them. I think that it's a lot bigger than that and covers all kinds of situations that include royalty agreements, gypsy brewing agreements, and other types of arrangements where someone is brewing beer for someone else who may or may not be a brewery. And so in that thought process, I really look at it almost as a license agreement, where the contracting brewery, not the brewing brewery, but the contracting brewery or contracting entity is licensing out the names and the recipes to a brewery that's going to brew that product for them and at their direction. Really the first thing you have to do, and this is critical in anything that you're doing in the brewing space, is knowing whether what you're doing is legal or not in your state. In North Carolina, this is actually a relatively new thing as recognized by state statutory provisions. And here I've copied on 18B 1104 A6A. But in this, it specifically contemplates and allows for contract brewing. Prior to the implementation of this statutory section in North Carolina, if you called our NCABC legal counsel, they would have told you that contract brewing wasn't allowed. That being said, prior to that date, there were dozens of breweries and would-be breweries that were doing contract brewing and simply doing it as a license agreement, and the state regulatory rules and the statutory provisions had not yet caught up with what's happening in practice. And I really see that across all types of different areas where this is such a new space, particularly in states like North Carolina, and has grown so fast that the rules just aren't set up to deal with it. So now, though, the state has recognized what folks are already doing, and our state, North Carolina, recognizes that very narrow interpretation of contract brewing, and that is when you already have a brewery permit and you're contracting with someone else, inside or outside the state, to brew your product. I've tried to cover the things I was just highlighting, and that is instances where you might use contract brewing. A lot of the breweries that, especially when I used to work with them, I don't know, 6 or 7, 8 years ago, in order to start a brewery, you might contract with someone else. In fact, Wicked Weed famously was doing contract brewing prior to them opening up because they didn't have their federal permit just yet, and they need to get the space open because folks don't like to pay leases until they have product that they can they can sell. And so in order to get that timing right, you'll often contract with a brewer that's already existing while you wait on your product to come in, and you're actually selling under an ABC retail permit, even though you don't have your brewing license from the feds or from your state yet. Similarly, very similarly, if you're trying to go into a new geographic market, and you want to build out the market before you commit to the brewery, or waiting on your permit, or you're waiting on your equipment, you might search around and find someone who has capacity, who has steel, who has some space there for them to brew that product for you while you get that new market ready to go. Private label, the way I use that is if a restaurant or a hotel wants that product and they want to have it under their own brand, and they don't want to go through the cost, expense, and time of having their own brewing system, then they may contract with someone to brew that for them. In states like North Carolina, lots of other states where you have cross-tier cooperation provisions in place, you have to be careful, really careful there about what that label says, and I'll get to that in a little bit later in terms of label requirements, because you don't want to violate those cross-tier prohibitions. Sometimes, and we're seeing a lot of this right now, there's a new product that you need to or want to get to market. We're seeing that with seltzer-based products right now, where breweries don't want to commit their space to that, but they know that there's a market for it now, and they don't want to miss out on that market, and so they look to a place that's doing a lot of seltzer product, and they strike up contract brewing arrangements to do the seltzer. There are gypsy brewers out there. Sometimes they are associated brands with actual breweries. Sometimes they are their own brands. I've got a client in Asheville that was winning awards as one of the top 10 best breweries in the nation on multiple lists for a year before they had their own brewery space, and they did it by collaborating with other breweries up and down the East Coast and building out their name and their brand that way. And lastly is in collaboration. Those collaboration beers, when you do a home and away with another brewery, that's a form of contract brewing, or can be a form of contract brewing, where there is a brewing brewery and there is a brewery that is cooperating with them, that isn't the one paying the taxes on it, isn't the one procuring the ingredients, isn't the one packaging it, isn't the one getting COLA approvals or anything else associated with it. They're just part of that process. I've used these terms already. The contracting brewery is the brewery that's licensing out that name and those recipes and who wants the beer produced. And the brewery or the brewer, that's who I'm referring to as the party actually making the beer. That is who the feds will look to. That is who North Carolina will look to as the brewer of that product. And they will be the brewer of that product and have control over that and risk of loss, etc., until the beer is received by the contractor. Fundamental parts of the agreement. I've got term on here, and it's a standalone piece is term because it is that important. And the reason that it is that important is when you are building out those markets and you are building out a contract brewing relationship, what you're doing is passing off some of those real estate pieces. And I look at the whole brewing industry as a real estate problem, but you're pushing that off to someone else and making sure that they're going to be providing that product for you or for whatever sector of your market that you're trying to get. And you want to have predictability on when that is going to end, and they need predictability on when it is going to end so they can turn that empty steel over to someone else and put product back in it. So you need to be real clear about what the term of this contract is going to be. Other parts that are really kind of these basic pieces, and these are the things that the contracting brewery and the actual brewing brewery need to talk about and put in writing and put down in an agreement. First one's pretty simple. That's control of production. The brewery is going to be responsible for those things. It's under their permit, both federal and state, but the contracting brewery will want the product to taste the same. And so if you have your flagship IPA, you want it to taste like all the other flagship IPAs of that brand. And so you want to have some oversight and involvement in both the implementation, the brewing, as well as the quality control. Label art, typically the contract brewery is going to be providing the label art and obtaining any kind of trademark protections that might be associated with it and providing those things to the brewing brewery. COLA submission, the feds are going to suggest that the brewery who is brewing it submit that. State label approval in North Carolina is called product registration. Can go one of two ways. The statutory provision I put up earlier requires the brewery to do that, but in some of these other unique situations that are still, in my mind, contract brewing licensing agreement, that may be on a different party, it may be on the brewing brewery to do that as well. But make sure that if you're going across state lines that you have your COLAs. And if you are in North Carolina, every single product has to be approved if you have your name on it. We do a lot of cost shifting, and so go ahead and list out all the costs of the beer, what the laden costs are going to be, everything from putting the caps on the cans to sleeves on cans to kegging, transportation. Put those things in there and know who's going to pay for them. The way I like to set up my contract brewing agreements is to have a cost at the end and let the parties figure out what that cost needs to be for both sides to make the money they want to make on it. And so it's inclusive of all costs. And I'll suggest some schedules towards the end of this presentation on that. Public statements, this is pretty critical and plays hand in hand with state labeling requirements. In North Carolina, and I'll put this up in just a couple slides, but North Carolina, there's some unique labeling requirements as well as for the feds. But how you represent this product to the world is likely to matter for the contracting brewery in terms of how they tell their story. And how that story is told goes hand in hand with confidentiality provisions as well. You got those comments for us, just make sure there's nothing there.
What?
Just the comments, just make sure.
Yeah.
Okay. Digging in a little deeper on our label requirements. I've got North Carolina requirements here, but it could be, you can start your state in there in terms of making sure you understand what those are. I just want to show this as an example. Pretty standard stuff here. You know, the brand, name of the product, name and address of the brewer, bottler, importer. In North Carolina, we have a class type of product, and for the folks that are in North Carolina watching, they all know that if you don't know what it is and if it doesn't fit in something that the state recognized, just slap on ale at the end of it, and it should go through. Net contents and the government warning statement. In these contract brewing situations, the federal requirements and our state requirements will kind of go hand in hand, but it's going to need to say brewed by, manufactured by, packaged by whoever the brewing brewery is for that brewing company and state. There are some breweries that will try to push this off so that it doesn't have to have that brewed by for language on there, so that it looks more like it's being brewed by the brewery who's the contract brewery, by doing different kinds of license agreements. And that's beyond the scope of this presentation. And I believe that's a pretty aggressive way to approach it. But I've seen some license agreements from some pretty big breweries, nationwide breweries, where they are licensing out the name and the recipe to a brewing brewery so that it comes across as though they're acting as a satellite location for the contract brewery. Label requirements, avoid misleading labels. That misleading labels part is put in there because of the last part of the brewed by and for, and what the feds in North Carolina want to do is to make sure that you're not misleading where this product is coming from and who's brewing it. And so that's why I said that licensing out of the name and having a satellite location, I think is an aggressive play. I've got this slide included, which is the 18B, which is statutory section, as well as our state rules section, which is the 14B NCAC, and that's related to our labels and what they have in contract brewing situations. The federal counterpart to that is the 27 CFR 7.22, and there's the text of that provision. I'm blowing through these slides. That's what I just had in the summary slide at the beginning. The 27 CFR 7.252 If you look at that, if malt beverages are bottled or packaged for a person other than the actual bottle or packer, that's why I feel strongly about that brewed by and for language being included, not trying to push that off. And that covers our labels. The rest of this presentation is really going to get into nitty-gritty of essential terms in a brewing services agreement. This is the kind of stuff that you end up reducing to writing, and I've taken these speaking points directly from several of the contract brewing forms that we typically use as our templates in these kinds of situations. Real simple on the manufacturer and supply side, orders, when and how made. Typically, it will say that the contract brewery will send an order at least 6 weeks in advance, 8 weeks in advance, designate whatever time that you need for the lead, depending on what kind of product you're making. But you need to be real clear on how those orders are made and when they have to be made. Same thing with payment. You want to know how that's done. I see a lot of breweries that will have the cost of the materials as part of the down payment, or maybe you put 50% down and 50% upon completion, but know what that payment is, again, when and how that's going to be made. Taxes are going to be paid by the brewer. That needs to be built into that pricing structure. The state excise tax liability is typically going to be on the receiving or the contract brewery. Packaging, again, be real clear on what you need. Do you need 16-ounce cans, 12-ounce cans? Do you need 6 stalls, half barrels? Whatever you need, make sure you've got that included into your agreement and that you have pricing for each of those things in the agreement. You also need to account for those extra little items of materials and labor, keg collars, can caps, bottle caps, labels in the cans. Are they going to be sleeves? Who's going to pay for those? Who's going to store those? Who's going to affix them? Who's going to assemble the boxes or cases or 6-packs? Make sure you have those things accounted for or build them into the pricing structure, because you don't want to be stuck with a whole bunch of product that you don't have assembled and ready for putting on the backs of trucks going out to your retailers or to your tap room. I referenced earlier in my comments that I really look at manufacturing of alcohol and storage of alcohol. The brewing business is very much a real estate game. And so through all aspects of it, in terms of where your equipment is, where the product is inside of your equipment, how many folks you have in your tap room, it's really a real estate game. How much space do you have? How long is it going to take if you get product into your customers' hands, whether on-site or off-site, and how many people have to touch it, and who's going to store it, et cetera. You know, all those things are really types of real estate questions. The storage of product becomes a big deal often because the brewery doesn't want pallets of your product sitting there taking up space or sitting on trucks that they own or warehouses that they own. They want that product as soon as it's ready for you to pick it up. And so you'll often have storage of product provisions in there where you're essentially paying rent for pallets of product, and you need to decide up front what that's going to cost and how it's going to be paid. And in that, you need to have a notice to pick up product, protocols, and a response, and a time to get that done. Likewise, you want to have provisions in, pretty detailed provisions in on cancellation. If cancellation of an order happens during production, how are those costs allocated? Obviously, there needs to be some kind of penalty to the canceling party. If it's after production and you've got beer that's finished, does the brewery get to take that beer, relabel it, or otherwise try to recover cost on it? Or does that beer have to be destroyed, and who's going to pay for it, and what kind of penalties are there going to be in those kinds of situations? Shelf life, understand what the shelf life is going to be. This ties hand in hand with how it's going to be stored and for how long. So understand those product storage protocols and shelf life. Shipping, risk of loss, that's a fancy lawyer term for who pays for it when it gets broken or stolen. So understand where that passes. If you are the brewery, you want risk of loss to happen sooner than later. If you are the contracting brewery, you don't want risk of loss to happen until it's either in your tap room or on your truck or in your distributor's truck. I've got this common wholesalers provision in there. Oftentimes, and I see this a lot in Asheville, where we have a pretty mature brewing culture where folks will brew product for each other from time to time. And when someone might have some excess capacity, or they have a festival coming up, whatever it might be. And so you see them often with common wholesalers, and I include this provision in if you have common wholesalers that you're able to use them. If not, you will run into an issue that the brewing brewery may have a wholesaler that they've lined up with, and the contracting brewery may have a completely different wholesaler. You don't want to have the two trucks scratching the head on who's picking up the product, who's authorized to pick up the product. So you need to be real clear about how that's going to work. Materials. Understand who purchases the materials. The way that I like to do it, and it's typically done because it makes more sense, is to have the brewery purchase those materials and simply pass on the cost to the contracting brewery. And again, that allows you to build it into pricing, but you need to have reasonable provisions in to allow for replacement. Hops, malt, whatever adjuncts of the materials might be going in. In terms of who owns it, I typically will put in, and default, I will put in that the brewery will own the raw materials until they are used. That gives that brewery some flexibility to move those pieces around. Likewise, the storage that needs to be built into the cost. But if you have a big run up on beer and you're eating up storage capabilities of the brewing brewery, then expect to pay for those kinds of things. The capacity piece, and we've seen this a lot, especially here in COVID times when alcohol consumption has gone up, that there's been limited capacity for some folks that are contract brewing. Understand how that's going to affect you if you're the contract brewer and you're counting on that product coming in, and the brewing brewery has too many orders coming in, and they've got to allocate on a pro rata basis to each of their customers a 20% or 30% or 50% reduction in their expected volume. So understand that. Again, that ties back to an earlier term, which is making sure you have good protocols and advance notice on ordering your product. Product warranties. What we'll do is that we will typically have a brewery warranty section and a corresponding section that's the contract brewery warranties in terms of representations that are being made. These are pretty typical and self-explanatory, but you want that brewer to warrant that at the time of shipment that the beer will conform to the formulas that have been directed. It'll conform to the requirements of this contract brewing services agreement or contract brewing agreement or brewing services agreement, whatever you want to call it. That it complies with all the laws of the product and complies with FDA, TTB, other labeling requirements. This unfortunate issue comes up from time to time, and that's how to deal with non-conformities. And when I say non-conformities, I mean beer that's bad. Either it's bad because it's spoiled, it's been infected, it didn't follow the recipe, it doesn't taste the way that it's supposed to taste. So in that, you need to make sure that you have a remedy for it on both sides, making sure that you can get money back, get credit, get replacement product. But you also need a way to figure out if there is in fact a non-conformity. In that, typically what will happen is the brewery will tell the contracting brewery that once you accept this product, you've got 5 days, 3 days, 7 days, whatever it might be, to determine if there's any conformity. If you don't identify a conformity within that time period, that product's deemed conforming and you have accepted that product. If the contracting brewery identifies a defect, then the contracting brewery needs to notify the brewing brewery and they need to have a discussion. And the brewing brewery will either agree there's a defect and there's going to be some kind of remedy, or the brewing brewery will dispute that there is in fact some kind of defect. If there is a dispute between the two parties, go ahead and have in your contract a process with a third-party lab, some other third party, to determine and verify whether or not it's a non-conformity or if it is actually good product. Once that happens, then you can implement the remedies at that part. But if you decide on that when you're doing the agreement, you don't have to come up with rules for resolving a disagreement at the same time that you are resolving the disagreement, because that is a recipe for disaster. You also need to have product sampling measures built into it. When can the contract brewery come test in line, off the bride tank, whatever it might be? How can they inspect the facility to make sure that what's being done is what's supposed to be done under the agreement? In this same section, you typically also have product recalls. From time to time, you might get exploding can issue, whatever it is, and without regard to whose fault that non-conformity is, when you have a product recall, you need to have a provision in that says if you have to recall that product, here's what happens, and go ahead and spell those provisions out. You're probably sitting here watching this thinking that all of this sounds like boilerplate, but it's not. But the boilerplate stuff is important too. The contractor warranties, I alluded to this earlier. These are pretty typical provisions saying that this contract brewery has authority to enter the contract, that they have the approval of their other LLC or shareholder members or owners. This is the important part, that they're the legal holder of the intellectual property rights. The brewing brewery doesn't want to be brewing beer and slapping labels on and be part of that process if the intellectual property, the trademarks, the names, the recipes aren't owned by the contracting brewer. And that the contracting brewer will assist the brewery with obtaining and making sure that all approvals and registrations, other items are taken care of, so that the brewing brewery doesn't get in trouble. Similar warranties for the brewer and holding permits and authority into that contract. Why do these things matter? These things matter. We'll see this later on with indemnification and warranty pieces. If something is the brewing brewery's fault, the contract brewer doesn't want to get in trouble for it, and the inverse is true as well. We have seen a lot of COVID-19 and other force majeure type events here during the pandemic. We have completely changed our force majeure language in every contract that comes out of our office to include pandemic protocols. But this simply means make sure you understand what happens if the brewer can't produce product or can't get raw ingredients or can't get product to market because of something that's outside of the brewer's control. There's also insurance that the contracting brewery can get to cover this item. So the contracting brewer can also get some relief even if the brewery can't produce the product for them. Trademarks in this, we typically have these roll both ways, where the brewing brewery is going to keep their trademarks, the contracting brewery is keeping their trademarks. The brewing brewery only has the limited use of that's consistent with the brewing services agreement and can't go any further than that. That's important for the obvious reasons, but it's also important for enforcing your trademark protections as against the rest of the world, to show that you are enforcing it in your own agreements. Indemnification, here's some example language related to what I talked about a moment ago, which is making sure that you're not signing up for some liability that's outside of your control and should be on the party. Insurance, we will typically have both parties name the other as an additional insured for those items that they are already doing. And you would send over certificates of insurance delivered to the other party. When you name someone as an additional assured in something like, in a situation like this, it should be no added cost to either of the parties, because they are only adding them on as an additional insured for something that's already insured. Do have limits in terms of your aggregate: 1 million, 3 million, 3 million, 5 million, in terms of single instance and cumulative. Termination, this goes back to the very first thing I talked about in terms of essential terms to contract brewing services agreements, and that is certainty by both parties of what's going to happen, so that you understand where there's going to be gaps in your geographic or your volume going to market. So on default provisions, obviously you need to have an understanding of what happens upon default. Is there any notice? Is there any opportunity to cure? What happens if there is bankruptcy or insolvency, or you lose your permit? You need to have those kinds of termination events. And then you need to have an understanding on how one party can cancel. Obviously, both parties can cancel with mutual termination. So I don't have that provision in, but both parties can always do that. Upon termination, you need to understand what happens to the product, what happens to the raw materials, what happens to the packaging materials, what happens to the proprietary information. In terms of the raw materials, I will often put in the contract that raw materials that haven't been put into the product remain as part of the property of the brewery. That seems to make sense. Same thing for the packaging materials, unless they are unique to the contracting brewery. And then formulas, recipes, and other proprietary information should always go back to the contracting brewery unless there's something being paid for those items. You also need to have in that's not on the bullet points here, but you need to understand what happens to the product that's there. If there is a termination event, who gets that product? What happens to it? Is it destroyed? Is it put into commerce? You need to understand what happens if there is outstanding amounts owed by one party to the other, and who gets the product, and who's able to recoup their money by putting that product in the market, if they can. Notices, this is just an important reminder to know who's supposed to get the notice in terms of actual person, email address, etc., and when those notices are effective. These are important for termination events, but also ordering events and other events. Understand where they are. There's no reason to question whether or not you got that notice if you've got in the right name, email address, telephone number, etc., and what happens and when it's deemed effective. Understand what state law governs the agreement. Pretty self-explanatory. And then exhibits to the agreement. Inside of the agreement, you'll make reference to these different things. The product list, obviously. Recipes will also often be included as part of that exhibit. The order and pricing schedule in terms of delivery and payment. Risk of loss, that's all typically on one exhibit, and it's maybe the most important exhibit to the entire agreement because it allows you to make sure that all those costs are being captured and passed on and being accounted for, so that both parties understand who's paying for what and how they're doing that. That way it allows you to price it correctly. The testing labs and testing procedures will also often be an exhibit to the agreement. Then the list of trademarks, as well as the proprietary information in terms of the naming conventions and logos, etc., will often be part of an exhibit to the agreement. I am happy to stay on as long as we need to answer questions. I've got our website here, as well as my email address, my direct dial, and our address. And happy to open up to questions that anybody may have about contract brewing services. question here is typically designate the state in which my client resides for the choice of law provision. Have you found any advantage to using another state, perhaps with more favorable contract brewing laws? I think that in my experience, the breweries state is the most logical for having that law apply, because North Carolina, for example, is probably going to make you do that, and it may already be applying as an operational law. But that's probably my snap opinion on that. But the first part of that, I typically do that too. No, we do that.